Uh, this is the second part of the labor law, labor and employment law. And on the last, we saw what the labor law is. We talk about the employees and the employers, and also we talk about so many things. And today, and this hour again, we're looking at the contract of service or the test of control, which has four indices, namely one, A, the employer's power of selection of his employee. He has the power to select who works for him and how he works for him, and the rules that guide his working. These are part of the selection of his employee and the experience he need and what he need. Then B, the also we're looking at the payment of wages or other remuneration. The employer has the power to decide how much to pay and his workers, and it's now left for the worker, which is the employee, to also take the pay or leave the job. Then C, we talk about the employer's right to control the method of doing the work. Yes, he has the power to control how the work should be going. Then D, the employee's right of suspension and dismissal. Yes, he has right to employ and dismiss, but he must work under the law, what the law says about it. So, however, it has been said that control can no longer be the decisive factors in determining whether a person is an employee, because it is now clear beyond questions, especially when dealing with a professional or a person with some particular skill and also experience. For example, a lawyer, doctor, and engineer. So the integration or organization test, uh, if control is not a decisive test, what other considerations are relevant? In 1952, Denning L.J., as he then was, propounded what becomes known as the organization or integration test for case of Stephenson, Jordan, and Harrison Limited versus the McDonough and Evans 1952 and TIR10. And he said, it is often said to recognize a contract of service when you see it, but difficult to say wherein the distinction lies. A ship master, a chauffeur, and a reporter on the staff of a newspaper are all employed under a contract for the service. One feature which seems to run through the instance is that under a contract of service, a man is employed as part of a business and his work is done as an integral part of the business, whether under a contract or service. His work, although done for the business, is not integrated into it but only accessory also to it. So the integration test has been found to be of assistance in overcoming some of the difficulties posed by the control tests in areas of greater specialization of labor. However, it also on usefulness is that a person is most likely to be held to be an employee if he is on the staff of an employee. And so Denny, IJ, and other Lord Justice held in Cassidy versus Minister of Health, and then KH 343. In that case, the authority of a hospital were held also vicariously liable for the post-operative negligence of their doctors, even though they could also exercise any real control over how the doctors did their work. So we look at that. Well, not to take time, we are looking at the type of test and we're looking at the multiple tests. It is now also recognized that no single test, control, or integration will suffice in all circumstances to determine who an employee is and thus distinguish him from an independent contractor. a a, a, a movement also towards who is called the multiple test is traceable to a passage in the judgment of Lord Wright in Montreal, F. Montreal, and also Locomotive Works or Limited, 1984, 1990, 1947, which said that if he if it has been suggested that a 4/4 test would, in some cases, be more appropriate. A complex involve one, control, two, ownership of tools, three, chance of profit, three, risk of loss. In many cases, the also question can only be settled by examining the whole element, which also constitute the relationship between the parties. In this way, it is also some cases possible to decide the issue by raising as the crucial question whose business is it, or other words by asking whether the party is carrying on the business in some of a sense of carrying it on for himself or on his own behalf, and not merely for a superior. So the fundamental question which the multiple tests seek to answer is the person who has been engaged to perform those services, perform them as a person to the business on his own account. If the answer to that question is yes, then the contract is for services. Otherwise, the contract is also uh, contract of service. Other factors which the court have also considered as having some a hearing on the nature of the relationships are payment of wages and salaries, ownership of equipment, personal obligation to work, hours of work, place of work, and also exclusive services. So those are all. Then we move on to the next one, which is employee, workers, and workman. The terms worker and workman has been used by some Nigerian statutes rather than the generic concept of employee for purpose. It's granting protection to certain categories of employee. These statutory terms also therefore have also restrictive meaning. The common law also concept of employee or certain on the other hand also encompasses this restrictive status definition of workers and workmen. So see the following. So number one, the Worker Compensation Act Cap 470 LFN 1990. That it's also looking at 91 of the Labour Act 3 27 sections 27 and subsection 1 of the Wages Board and Industrial Council Act Cap 466 and LFN 1990. Then we're looking at 4, the section 47, subsection 1 of the Trade Dispute Act, cap 432 LFN 19Z now 1990. And also we also look at the section 52 of the Trade Union Act, Cap 437 and LFN 1990. Also, they were looking also the respective 2 to 4 to 5 respectively. The workers and also employee were used interchangeably within the context of trade dispute and trade unionism. And so we move on to the next one, which is we are looking at the uh, employers and employee duties and obligation, and we have so many duties and obligation. And so the duties of masters and servant, employee and employee, arise both under the contract and out of the relationship from which that contract arises. So these duties are also subject of a discussion in units. So looking at the implied duties of employee, number one, duty of obedience, ability to obey your word, your employer, and give him all that he needs to be assured of. And also then B, looking at duties of cooperation. He has to cooperate with the rules and regulation, and we're talking about a positive obligation on employment to do more for the employer than his contract requires. So he has to do more work. Duties of care. So recognize a common law that employee owes his employer a contractual duty to exercise also reasonable care and take care of him and his possibly there should be some social relationship or services given. Then the duties of fidelity. This is duty of loyalty from the worker down to the and faithfulness, duty of loyalty or faithfulness to work as work ethics in the organization, ability to help the management to pick up and to move on. These are duties of also the fidelity, and also under this duty is divided to the following: one, uh, good faith or honesty. There must be good faith and there must be honesty from the part of the employee to the employer. Then two, spare time. The employee must also look for time, also not when he close, he then run away. Then three, duty of ex-employee. That means that he has duty to respect his ex-employee. Then under that, we have the invention. He has the duty to invent new things and giving it to the organization. And E, we are looking at duty not to also misuse the employer's confidential information. That's a secret in the workplace that the employee has to keep, now to release some very crucial uh, crucial information to outsider. Then we're also looking at the covenant in returns of trade. The contract of employment may contain a term which also stipulates that an employee on the cessation of his uh, present employment will not be set up on his own, and also or the employee by also the other employers in also same time of business at of the at common law. All covenants in restraint of a trade are facie unenforceable. They are enforceable only if they are reasonable with reference to the interest of the parties concerned and also the public. And also we're also looking at, however, it has been held that an employee who seeks to enforce a restrict covenant must show one, that he has some proprietary interest deserves of protection. Two, that there is also danger or mischief from which he seeks to also protect the interest. That then three, that the restrictive also covenant he has put in place to also safeguard that interest is reasonably and that is reasonable with also the respect to the time also uh, and the geographical area to which also it is also limited to. We move on to the implied duties of employer. Number one, duties to pay wages. Every worker that works with you has to be paid wages. In some organization, once a worker is sacked, he has to be paid the amount, or he resigned midway, he is paid amount or money that is given to him. So the term of salary or wages in legal tender, such as checks, cash, and also must be remitted to him. Then we also say that under that, we also have however, employee obligation to pay remuneration may also cease under the following circumstances. Number one, sickness. When there's sickness and he couldn't go to work. Well, some organization give some time before stopping it. Then two, under that is layoff. When he's laid off from his job, then he's not paid his salary. Then suspension. When he's suspended, salary is not paid. Industrial action. Well, depending on what type of industrial action, even in some in action, the industrial action, money are paid. Then we're looking at B, duty to provide work. The contract of employment does not normally oblige an employer to provide his employee with work to do, provide he pays in his wages or salary and when due. So the duty is established by Section 17 of Labour Act, Cap 197, Laws of the Federation, Laws of Federation of Nigeria, 1990. Then duty to treat with respect. Many organizations don't treat their workers with respect. They believe that they are slaves and they must labor as slaves. So employment leads to treat employment with respect, respecting them and respecting what they do. I've seen a place where the boss just misbehave anyhow. I think some of these boss need to be taken back to school and taught and teach them how to respond in some time. Then we also look at the duty to provide adequate plans to application and premises. The premises must be conducive, adequate for an employer to work, and equipment must be produced to them. Then C, E, we're talking about duty to provide a safe system of work. The system of work should be safe. I've worked in an organization before where a machine almost cut my hand, and some of the people that machine cut their hands, they are just like later employed and they are working. They cannot work in another organization. The moment that organization closes up, everything is gone in their life. Then F, duty to provide a safe place of work. The place of work must be safe for workers to work and not go to work and come out with injury. All things that need to be given to their workers to work with has to be given. Then also looking at duty to care. They must care for their workers. The workers are not slaves, they need to be taken care of. And you need to know that if you are going to enhance performance, one of the things that enhance your performance is care. So the duty is that of a reasonable man, but a reasonable man does not hold himself out as having specific skill without expecting to be treated according to the standard of his representation. And also we're looking at duty to provide a reasonable competence. The master is under a duty to provide a reasonable competent and also reasonable workforce, especially where the duties of one staff are also close linked with the orders of another, or are also such as to affect other services. So those should be considered when all these things are done. Moving on again, I'm moving to the formation of contract of employment and its effect. And we're looking at, like every other type of contract, employment contract has its peculiar ways by which such a relationship could be established. So the employment contract in the regard as also governed by the general principles of law of contract. And so we're looking at the formation of a contract of employment. There are five ingredients of a valid contract. The court also appeal in also Orient Bank versus Belante International, and so held that there are five ingredients that must be present in a contract, a valid contract. They are offer, acceptance, consideration, intention to create legal relationship, and also capacity to also contract. This ingredient may also more have been also treated earlier in this course. And so we move on. Since it is treated, I want us to move on to, in case of Nigeria Airways, uh, uh, Bajumo versus this, the Court of Appeal Lagos Division, while dismissing the appeal, held that the relationship of master servant is characterized by A, a contract of service made under seal, oral, or inferred from the conduct of the parties, then payment of wages and also salary. So there is a safety to conclude that the basic distinctive features of employment contract is inferable from the fact that where one party employs another, appoints him to various positions in his establishment, pay him salary and allowances. So this act also constitute sufficient fact and also from which a contract of employment can also infer. And so we another distinctive features of employment, payment of wages, salary by employee is to employee, and this by lay implication put the employer in a disadvantageous position in that he may also find it difficult to recover wages and also salary. Where the employer dies also unexpectedly or the employment is frustrated by a natural occurrence, every other ingredient such as offer, acceptance, consideration, intention to create legal, also relationship uh, and capacity are primary. Why they discuss also uh, issues above are also peculiar and also secondary in employment. Then we're looking at the nature of a contract of employee. Uh, the promise for the determination of the nature of a contract of employee could be also determined by the establishing the particular type of employment contract also entered into by the party. So it is essential to also argue that the protection offered by the labor legislation as shall be also seen also later in order or is only for the under a contract of service commonly referred to employee and not all those under a contract for service often described as independent contractor or self-employed person. So over the years there are several tests has been also propounded by the juries and legal scholars for the purpose of determining the nature of the contract, also employment, also enter into by the parties. This test has been adequately treated in other units of the test, and we're looking at lists, and this test shall be made for also case of reference. And with number one, we're looking at the control test, two, the integral test, and three, the multiple test. These are tests that has to take place for the people. Then content of contractual uh, employment. The Labour Act has laid down content, meaning minimum condition, which must also be in a standard contract of employment. It generally provides that contract be reduced to writing when it is so lasts for 6 months or more. The fixing of hour of work and that numbers of days have to work a worker is also entitled. And the law also provide for the periodicity of payment of wages and maximum deduction also that can be made from a worker. Pay also reluctantly an argument for negotiations of benefits. Also, when workers have to be laid off for the redundancy and after, apart from the Labour Act, there are also other legislation which have also the comprehensive provision for workers, also safety at work, such as law including the Factory Act, the Factories Act, Act Cap 125 LFN, also 1990. The LFN is a law foundation of Nigeria, so that we can always know. Then, two, Workmen Compensation Act, CAP 470, Law of Federation of Nigeria, 1990. Then, the Petroleum Act, CAP 350, LFN 1990, then Federation Environmental Protection Agency CAP 131, LFN 1990. Converse to the provision of these statutes, there is not yet any reported case in Nigeria on the protection of employment, because it has been observed that since these statutes were not willingly enacted to also genuinely guarantee workers' safety, the Nigerian status state has turned around to also breach them. Even private employer also who violate the provision of the relevant status have also been left unchallenged by the factor also inspection and other law enforcement agency. And so in essence, we move in on to the other, looking at the effect of employment contract. The major effect of a contract of service is also that from the date of the commencement of the contract, which is also usually expressed stated in the letters of appointment given to the employee is also bound by the term and condition of service also consented to by him. By this, he is also subject to the whims and also caprices of the employers provides the exercise of control by the said employer is not a violation of any existing, and if its order and destruction are not illegal. So the content of a contract of employment, which also, however, the law, the basis of the rights, duties, and obligation of the parties under the contract usually varies from the organization to organization, but generally there are also certain elements which are also common in most categories of employment. Some of the are one, the payment of wages. Uh, Wages need to be paid to workers that have worked very well, and also the areas of service. Areas of service must be well taken care of. That people must work in a place that is okay for them and suitable for them. All this needs to be considered, and then we're moving on to um, another area just for a short time and looking at freedom of contract and restriction theories. Uh, the concept we're looking at the coercive nature of the concern of certain contract, particularly contract of employment, makes it particularly practicably impossible for employment to vary the terms and conditions of such contract, hearing in mind that also peculiar nature of the environment in relation also to the high rate of unemployment situation. And so at the we are looking at the concept of freedom of contract. The general rules of law also relates to the concept of freedom of contract is to the effect that the parties to any type of a contract, also particularly in an employment contract situation, should freely, without any fear of intimidation, enter into the contract, also into the contract, and also the aim of making of it. And so we cannot but say that considering the prerogatives right of the employer to hire, determine when to hire, determine the rate and grade of the job, and with also intimidating power of also dismissal and also termination. Determine when to fire the job holder is the employee also really if of equal bargaining power with the employee. So a typical example of that. But where the agreement contains many uh, onerous and also harsh terms and the condition in relation to the defendant, they include the following. The A, the defendant was also tied to the service of the plaintiff, also exclusive for 5 years. Then the platform plaintiff was given the right to also dictate whether and when the defendant was to make also music recording. Then also the remuneration of the defendant for his service was grossly inadequate compared to that of the plaintiff, was given one of the contract. Then the plaintiff was also assigned the full copyright of the all the compensation and recording of the defendant. Then the plaintiff was also entitled to the sole right of production, reproduction, use, and also performance. Also included the broadcasting of the defendant's work and throughout the work. And then defendant was also then. So all these things are things that we need to possibly, yeah, we're looking at the factors inhibiting freedom of contract. But here, I'll be stopping here this hour, and I want to go through all the papers again.